assist you and your clients. Today's topic, well-publicized cannabis and real estate. How does this affect you? How does this affect your clients? How does this affect you as homeowners or tenants? We're going to try to cover the basics today. I do want to emphasize that this is it's brand new law and it's evolving. So we're going to try to steer you through the law, but we actually are in a position where we're going to have, it's almost like a wait and see, because none of these cases have gone to the court yet. So this will evolve, and I think we'll probably have to circle back in about a year or so, revisit the topic and provide an update. So, and if there's any input that you may have or insight, feel free to elaborate. Okay, so Cannabis Act, we all know, well publicized, came into effect last week. Effective as of October 17th, it creates a strict legal framework for controlling the production, distribution, sale, and possession of cannabis across Canada. Now, I did this presentation at another office, and it came out, I thought it was 19, and like the legal age for smoking and drinking, I believe, or whatnot. It's actually 18. Okay? And so 18 years of age or older, persons will be able to possess to a maximum of 30 grams of legal cannabis, dried or equivalent in non-dried form in public, share up to 30 grams of legal cannabis with other adults. Previously, I think that would be construed as trafficking, right?
Sharing, you can't exchange money. It's like it has to be a gift, or it's considered a
trafficking.
It's a transaction. You're selling a Facebook share. There's no money involved.
Yeah, exactly. Just a nice, good old-fashioned gift.
Thumbs up.
Lastly, to buy dried or fresh cannabis and cannabis oil from a provincially licensed retailer. I think what were the numbers? 150,000 went online and purchased last week. So that's essentially what they're trying to do in limiting access and controlling the amounts that are obtained.
What does 30 grams look like in pot?
Monica?
I know, I'm serious.
Monica, miss, you were here.
It's like a Ziploc bag.
Yeah.
See, I know.
Okay.
Like that?
Yeah.
Like that.
1 ounce is 28 grams.
Yeah. Salts.
So yes.
You must be cooking a lot.
You missed it, Monica, for the record. I've never tried a joint. I don't laugh. It's true. She just does this.
Apparently you did, according to Daniel.
Okay.
Sorry, Gary.
It's legal now.
Legal.
He got me really well on that one.
50,000.
Okay, so I don't have to hide it, right?
Gary,
Yeah.
if I can just
Absolutely.
I just want to, excuse me guys, I just want to bring up while we're on that, and Gary's talking about the grams and that, but the last part was the legalized side of it. From the realtor's perspective, I caution all of you, because you will be approached. I've been approached many times before this, actually about 2.5, 3 years back, that you might have clients that are going, I'm looking to lease a spot, commercial especially. And Brian, you know that, right? They've asked for these spots. You go, well, what for? They go, well, entrepreneur. Yeah, right. What for? They're not legal.
My friend saw that the day it became legalized, an actual landlord had a note on the door to the tenant saying, "You're not allowed back in this premise."
Oh wow.
Yeah, basically saying like you can't.
You've been evicted.
Yeah, like
That's just be careful,
Yeah.
be conscientious of this, because they may say that if they say there are legal rights to do this, you go, well, I'm not the one. It might have to be a condition. Look at their forms. They got licensing program. This is really tough. About 2 months back, I was at a session where they had the guys who were doing this, like from the ministry. And
Yeah.
believe me, they have different levels, right? Retails and this and that. So I just want to bring that up. Food for
Yeah,
thought,
absolutely.
guys.
And we're touching landlords at the end of the presentation too, briefly. Controlling access. So please note, you can grow from licensed seed or seedlings up to 4 cannabis plants maximum per residence. Okay. In any dwelling unit, 6 or more if it's for medicinal purposes. So regardless of how many persons are living in this dwelling unit, it could be 6 or 4 or 5 or 6, it's a maximum of 4 plants per residence, okay? So that's very important. It's not per person. That applies regardless, again, of how many adults are living in there, whether they're children and whether the dwelling is owner occupied or rental apartment or any other form of dwelling. So whether it's a home or a rental apartment, it's 4 plants per dwelling. Okay, any questions?
Could there be a clause in a lease that says that the tenant agrees not to, or would that negate?
I think you can actually,
can.
you try to insert it. We don't know at this point, I think you can.
You
Just
can
like no
reinforce- you
smoking
can
in your
enforce
standard
Yeah.
standard form lease. Now you can put no smoking. I think you can absolutely put it in there. Whether or not it goes to the landlord and tenant.
Yeah, this is the one that, and just Gary's talking about clause 10.
Yeah.
Right, the smoking part here.
Yeah.
And Gary's 100% right. You might try to put it in, but somebody could challenge it. We don't know.
Yeah.
Nobody knows really, honestly, what's gonna happen here.
We have to wait till it goes to landlord and tenant tribunals
Yeah.
and maybe even court
Smoking
on
and
that.
growing are 2 different things.
Yeah, absolutely.
Yeah,
Well, just if I can interject, there's also the problem about the heights, because these plants can grow I don't know if you realize, one plant can circle this room about 4 times.
well, that's it, right?
That's one.
Yeah.
Just saying, I read this.
Larry's got a lot of technical details on this.
No, for the medicinal purpose, the
Yes.
cannabis oil, it would be advantage to go to a doctor on that, right? To see if it's,
Absolutely.
Yeah.
Definitely seek medical certification
Yeah, on that.
and see if
Yeah.
that would assist. I understand from what I've heard, it may have a slightly different effect or as opposed to smoking, but I think that's an option there. You may, and as of next year, edibles will be legalized in 1 year also. Question?
Yeah, I was gonna ask, it says the legal age is 18. Is that to smoke it as well? Like, because we see high school students who are under 18 smoking.
Oh, they all smoke.
Yeah, so does that mean that
So
they're doing it legally?
from what 18, yeah, 18 is to smoke, 18 or older presumably.
Not just to purchase, but to smoke it as well?
Yeah.
That's the presumption, okay?
It's like alcohol.
Yeah.
Yeah, what about electricity use on the premises? For example, depending on the lease or whatever the situation is, hydro is included, it's not included. Often they have a lot of electricity used to keep these plants
Absolutely.
going, and it depends on the quantity. I don't really know what the ratios are. But, I mean, for example, if the landlord is responsible for electricity, or it's included, or whatever the arrangement is, or if it's a partial split,
Yeah.
this uses up a lot of hydro.
I think you have to have
And then-
them pay
and then
for their
or they start putting in
hydro.
all kinds of other
Yeah.
things to help.
So I think it's a
run
very
plants.
valid concern.
So what happens with that, with leases and?
Well, essentially, you try to have them pay for their own hydro, have a meter, maybe install a meter. But let's deal with the landlord questions towards the end when I get to that section, because I know we want to get to that.
Yeah.
It's very, very important.
So
Brian?
you can do 4 plants. Let's say if a tenant does 6 plants and the cops come busting, is that a grow-up?
Well, it's illegal.
That's illegal.
It's illegal. They're in contravention of the law there.
Does the unit become known as grow-up, and if we ever want to sell now, it has to go?
Yeah, well, you know, my understanding from what I've heard from talking to a few of the people that were at conferences with people who are producing, lawyers who are involved, people from the real estate section. We don't know at this point in time, but technically, if the property posed a risk, a risk to your health, for example, if there's mold or whatnot, because of the actual pot, must be disclosed. You're sort of, that's a great example because you're borderline. It was 2 extra plants. Does it pose a health risk? So we're gonna have to wait and see, maybe Trev will bring in on this or.
And not only that,
or
Brian,
Rick.
the reality is typically what it was anything up to 99 plants is considered a grow-up. So if you're busted in Canada, you get suspended. If in the States, you can do 5 years immediately, prison time, like immediately. So it used to be up to 9 plants, 10 plants. The catch is, were you selling? That's all they're gonna look at. Then will it be reported? You gotta be careful here because we can't say that the seller has to disclose. The seller
No.
may be a landlord going, wasn't me, but they did it, but it's on the radar.
Yeah.
And that's, again, where Gary's going with this, with the
Yeah.
landlord tenant, so.
Since this law has changed, you know, has anything come in terms of, you know, a prosecution, a charge?
No.
Nothing that we're aware of
Not-
has changed.
Prosecution, no. Charges?
Charges?
But they shut down.
They shut down the
illegal
distributors. The illegal dispensaries. They were charged, but it hasn't gone to court yet.
Right.
It's just way too quick. You're probably looking realistically 6 months to a year.
And are these stores, these dispensaries, are they open currently?
They can,
They're
but they're
Legal.
No, there's no legal dispensaries anymore.
I'm confused.
They have to be,
They passed a law that it's legal,
But they're not allowed to sell it in stores, they're only allowed to sell it
online.
Online, now it's online.
Online through
And so you said, In a
government.
week, 150,000 people made a purchase?
I think
Yeah.
last week, yeah,
Wow.
that was the number of orders.
Averaging $40 a purchase, that's $6 million.
Almost more.
You're calculating money, funds, revenue now.
And they're a postal strike, so you're.
Okay.
There's a postal strike.
Now,
Yes, that's why the UPS guys are so
so
around.
we're just gonna follow up here.
Stone.
Access. So, can make cannabis products such as food, drinks at home as long as organic solvents are not used to create concentrated products. But as I had mentioned previously, cannabis edible products and concentrates will be legal for sale approximately 1 year after the Cannabis Act. So, don't try it now. It's still illegal, okay, for another year. But this does pose some options. Any questions about this? I have some clients that next year will be investing in that type of business or whatnot. What can landlords do? So now we're getting into the landlord questions. So the Residential Tenancies Act does not discuss smoking in a rental unit. Period.
I thought it did. I thought you just mentioned it did.
It's on the
Standard form lease.
You
It's
can,
not in
they
the
can
Residential
address it.
Tenancies Act. Okay, so it's
Oh,
on the standard
okay,
form
okay.
lease. So that's why that lease, that new form is critical.
But a lease can be negotiated.
Yeah, you can put the terms
Yeah.
in. Section 61 of the RTA, tenancies may be terminated if the occupant of a rental unit commits an illegal act, which is what we had previously discussed. So the Landlord and Tenant Board has held that tenants or their guests who possess or use marijuana without a medical marijuana license commit an illegal act that provides sufficient cause to terminate the tenancy. That was previously. Once recreational marijuana is legalized, landlords are likely to basically be able to rely on Section 61 only in narrow circumstances, such as if the tenant is actually underage. Okay, so be aware of that.
Or if they're growing
Gary?
6 plants.
Yeah, 6 plants, that's illegal.
6 plants is illegal.
They're in contravention.
If
Yes,
you're
Monica?
renting a condo unit and the condo court says there is no smoking of any kind on the common elements,
Yeah.
which is the balcony, and there's no cultivating of any cannabis inside the unit, you can get a tenant out on that. If they are doing it, you can.
Yeah, absolutely.
That's an illegal act.
That's
So-
actually further in his
And
dialogue
that,
there about
we're coming to that very shortly.
declaration.
Because a lot of condos are moving towards this non-smoking, no marijuana clause. And I sit on the board of directors on a condo corp, so
They've already done it ahead of time.
Oh, yeah.
They wrote it up quick.
it's already really, yeah, and I've seen them, so, and we'll cover that very shortly, Monica. So, what about other options? So, you've got a tenant here who obviously is using marijuana or whatnot. You can rely potentially on Section 64. So a tenancy may be terminated whereby the tenant is substantially interfering with reasonable enjoyment of other tenants in the actual property or the landlord's reasonable enjoyment of the property. So you've got someone who is using marijuana, smoking or whatnot, and we all know there's a strong odor. So if that's impacting the reasonable enjoyment of neighbors in this property, other tenants or the landlord, then there may be cause under Section 64 to terminate the tenancy.
Maybe.
Maybe.
That's right.
Give them like 60 days, 90 days notice, what is it like?
again, that's gonna be just like anything, it's a sixplex, five of the renters are all complaining, going, this is my kids, or this, we smell it, come on, what are you doing? They put a claim against you, so you may end up down at,
The
Shepherd.
LTB.
Right, and they go, well, I need it, and that's my problem, then they go, he said, she said.
And then landlord and tenant board.
And then you never know.
Tribunal might say, well, they're in the right,
Yeah.
no, they're not in the
So
right.
the, Gary,
Question.
excuse me, is that limited to smoking on the interior? What about balconies?
Again,
A lot of condos are moving to a zero
Tolerance, right.
Zero
Interior,
tolerance.
exterior. is
Interior,
something
even
about it
interior,
that
right?
comes up into other people's
Yeah.
windows.
even inside your own unit, even on the balcony. So, and we'll talk about that specifically when we get to the condo section.
Okay.
Because it's very, very interesting what was drafted and what I've seen. And it's very strict, actually. So, first point here, more difficult to establish, obviously, than an allegation that the tenant has committed an illegal act, since whether interference is sufficiently substantial to warrant termination, as we had discussed, is fact independent. So it's a case-by-case analysis, okay? In one case, the Landlord and Tenant Board determined that a tenancy should not be terminated for substantial interference despite multiple complaints by other tenants. The LTB held that the evidence demonstrated that the tenant only smoked outside the rental unit, though still on the property, and possessed a medicinal marijuana license authorizing her to do so. I think this is more of a human rights issue,
Yeah.
as opposed to,
Recreational.
right.
They're picking on me.
I suspect that maybe if it was recreational, that probably would have been a different ruling there. Okay, so, and that's the point, we have to now be very cognizant of human rights now, in conjunction with this Cannabis Act. Any questions?
If you tell a tenant, look, we're okay with you smoking on the premises, just not inside the building, like, can that be enforced?
It would be up to the landlord to try to enforce it and police it. It may be very difficult. For my preference, I think if you have a landlord client, I probably think you should just move to total no smoking.
No, or if you buy a building that's already has somebody that's either smoking, just
But then you've
somebody that's
inherited.
marijuana.
If that was on a previous
but there's no lease.
no lease agreement, I still think they might be exempt because of that previous. They haven't. So it's going forward, executing any new leases, then you're bound by this. But so if they were under a previous
My
lease,
question-
they're under those terms.
I get that, but my question is, can you force a tenant to say, look, we're okay with you smoking, just not inside the building, you have to go smoke it
That's
outside?
back corner.
You may have had to put that in your standard agreement then.
No, but this is if you inherited, like.
You can't, that's hard to tell
Halifax
someone.
could say, well, Mr. Smoker,
Yeah.
you used to smoke on the sidewalk and now you can't.
Yeah.
They did
Yeah.
it.
I think again, we don't know at this point in time. You're gonna have to wait till the cases get to the.
What are you trying
Well,
to
that's
Landlord and
true.
tenant.
People might do that. Don't kid yourself. I'll give you, just to digress 1 second, at RIA, okay, at RIA, when I was teaching these courses over the years, they actually built outside near the parking lot, those were smokers, they actually built a shed out
Right.
there, and they're going, you can't smoke here, you go over there. They go, okay, fine. They all walked out like rats every after break.
It sounds like Joe's asking how you can enforce that. You can build a shed, but they may not go there.
That's right. The point was they didn't all go there and they smoke, and that's why you see the signs on the building. Must be 9 million, all
I
these.
mean, you can put in a million rules, the
Yeah.
tenant is gonna do it.
Your questions
Yeah.
are
So, and you
warranted.
won't find out as a landlord, so everybody will be happy. You don't know he will do that.
It's
Nothing
gonna be
happens.
coming
It's
up
when
case by
the other
case.
tenants
Yeah,
complain,
complaining.
though, and that will become an issue. And we'll just have, like, as Joe pointed out, we'll have to wait and see until it gets to the LTB and what the case law will prove.
When it comes to possessing medical, like from a doctor, like getting the permission from a doctor,
Yes.
does it have to be a specific doctor, or can it be like,
Oh, it's so
I've
easy.
heard it's, yeah, so like anything can be used, or the excuse can be like, hey, it's from a doctor, it's for medical reasons,
Right.
or is it from a specific, do you know?
I can't comment on how well thought out this policy was.
I think it's
Yeah, I
more of
can't
a
make
promise
comment.
for the election.
Right, I think that's a very valid point, and, maybe it's a matter of setting out regulations of who gets approved for those licenses in a better, maybe a standardization process.
So I can see that being an issue. Oh, they're using it for recreational, but then they're getting it from any doctor.
So this is very, very key. We covered this in our standard lease form presentation. And as Larry confirmed also, in your new standard form lease, in section 10, the landlord tenant can use that section to agree to either allow or prohibit smoking in the unit and or on the landlord's property, as Joe was pointing out. There are so many concerns with humidity, mold, and whatnot. Power. Why not just make it a no smoking? It's just clear. Unless, you know, you want to try to be reasonable, it's up to your landlord clients to decide. Okay?
Here,
Yes.
if a tenant agrees to it and signs a lease that says no
Yes.
smoking, and then later says, well, I'm going to challenge you because it's fine, but they agreed to it initially.
Yes.
So do they have any footing for a challenge later?
So this is a great point. One tactic that may be employed by potential tenants would be, I'll sign and agree. You know, 2 months pass by and they start to smoke.
Right.
Okay. So what are your rights as a landlord, or your client's rights? Well, there is case law on this. Okay. And it wasn't on marijuana, but it was on tobacco. So we have to try to
As a precedent.
As a precedent.
Yeah.
So we'll, in that case specifically, you had a landlord, condo board, tenant. Tenant and landlord signed off, no smoking in the actual unit, okay? And then they started to smoke. The condo board received complaints from neighbors or other residents in the actual building, and they complained to the condominium board. Condominium board issues notice to the landlord then talks to the tenant. So you've got 3 different parties involved there: condo board, the tenant, and the landlord. So this all, so there were 2 issues here. So the condo board just went directly and launched a court case for
Against the landlord?
Against the landlord for order of compliance, and I think they named the tenant also. Okay, the landlord did make efforts to try to curtail the smoking. The tenant refused to. And then they submitted an application to the LTB. So you've got a court case here, you've got an LTB. And from my understanding, what happened, and the defendants, landlord and the tenant said, wait, condo board, you really should have waited for the LTB to go through their process and then go for that court order. But, so I went to the courts and the judge decided, you know what, tenant was in violation. Okay. The condo board and the landlord were each out $25,000. The court ordered costs. So who's going to pay for the legal fees now?
The tenant?
Tenant had to pay, but, here's a but, the tenant was only forced to, or ordered to pay $10,000 on each of the condo board's legal fees and the landlord's legal fees. So the condo board and the
Landlord, make a deal.
and the landlord were out of $15,000 each.
So in other
So
words,
you have to tread
in
carefully.
order to satisfy the other owners in the condo, in the building, the condo board had to take legal action,
Sure.
and thus creating an enormous legal bill.
Yep, under section
Because they
15.
had to say we are taking action instead of waiting.
Absolutely.
Because they had to show to the other owners that they were doing something.
They were probably being pressured.
Okay, and then, but the owner of that condo unit who has the delinquent tenant is responsible, even though he's absentee, because he is the owner there.
Absolutely.
And therefore, anything that's happening in that unit is under his supposed control. So he's liable.
I would
Okay, so
presume so,
then,
yes.
so then I guess, I don't know, there was a countersuit, but they went to the landlord board who said that the
LTD.
tenant was in violation, but everybody was out a lot of money.
Yes.
And it wasn't really prudent, if you think about it, for the condo corp to directly start legal action, but they did it out of pressure, probably from the other,
We're surmising, so presumably that was...
probably. And as a result, there was over $50,000 legal fees spent. And
The condo board has a duty to promote the health and safety and welfare of the
so any
all
unit
residents.
owner is going to be legally responsible.
absolutely.
Absolutely, it's just like insurance. I mean, regardless of if something happens within that unit, regardless if you have a tenant who has tenant insurance, if they don't have insurance, the landlord is liable in any event. So, you know,
But the thing is that the landlord, I mean, aside from saying at the end, okay, the tenant was responsible, he just went through an enormous expense and headache.
It's a risk you take.
Welcome to being a
So
landlord.
that can happen to anybody that owns a
You
unit.
just have to
You want to
be
be a
careful.
landlord, that's what comes with it.
Guys, don't do
Okay.
leases.
I'm not saying don't do leases, just be a little more diligent. That's what's good for. Okay, what else can landlords do? Landlords can continue to police and prevent behavior that raises the risk of fire. So this was raised, Larry talked about this too, electrical load, okay? There's a risk there. Damages the building, such as elevated levels of humidity, which leads to mold. Interferes with the other tenants. They can complain about potentially the smell of budding cannabis plants. So we've covered that already. Now what can tenants do? What if you're a tenant, or your client's a tenant, and there's another tenant in this building or whatnot, or next door who is smoking cannabis. If the tenant believes that other people smoking in their building affects their health or safety, which is a recurring theme, okay, contravenes maintenance standards, or substantially interferes with the reasonable enjoyment of their unit, again, recurring theme, they should discuss attempts and document it, either via emails or letters, conversations, or you have witnesses to your conversations. I think that would be prudent. That question about what if someone was a previous owner, I know that we sit on our board of directors, I sit on our board of directors at our Townhouse Condo Corp, and what we did was, okay, how do we address current owner concerns, or tenants even, that are currently living? We grandfathered them. So if you are a current resident, or an owner, you are grandfathered from the rule that we're going to be passing next week. Okay, you're exempt. However, once that unit is sold, or that tenant leaves,
Doesn't get carried.
okay,
Yeah, it doesn't get carried.
it does not carry over. Okay, so the new owner or the new tenant must comply with the bylaw.
And that's
Rules
usually
and
voted on
regulations.
by 80% at least.
Yeah, or you can do it as a rule.
Right.
Okay.
Just, well, I guess, because it's just kind of read, but it's like, if the condo's trying to add it in to no smoking, can't the residents of the building challenge?
Absolutely. So our procedure was we actually discussed it with the board of directors, we discussed it with our legal counsel, and then what we did is we drafted it and sent a draft
To everyone.
copy to everyone, to all the unit owners and all the tenants or residents of the complex. We have 80 townhouses in the actual complex. And you know, I was astounded at the feedback. Okay, out of the 80 townhouses, does anyone want to take a shot at the percentage of how many challenges we received? Challenges, let's 30. 30, I've got 30.
I was gonna say 30.
5, okay. Anyone else?
80.
80. Everyone. From my recollection, I could see 3 emails.
Oh, wow, that's good.
So
And no-
when you're mature.
And no
probably
strong
it's
objection, it was just, well, how do we smoke, or if we're grandfathered? So,
That's the idea, it's how do you, because I have a client who bought last year in a townhouse complex, and now they're passing a bylaw, and he's like, what the hell, man? He goes, I'm gonna have to sell now, thinking, like, he doesn't smoke, weed, he smokes cigarettes. Because how can I barbecue and have a beer and not have a
So.
so with our complex, I'm not sure with his particular complex, anyone who is grandfathered can still smoke inside their unit, okay? B, they can go up to the rooftop deck, we're permitted there. But what they can't do is go outside on their porch or their veranda or the front section and smoke on the common elements.
Can't sit in the backyard and have a
Can't even sit in the backyard, only the rooftop, because presumably the smoke goes up.
Makes sense.
Yeah,
So, but if you're the owner of your townhouse
Yes.
and you have a patio, you can smoke.
patio on the rooftop?
Patio?
Well,
Yeah.
in our complex on the rooftop, you can go smoke if you're grandfathered.
Oh, and if you're new, you cannot smoke
Zero.
in your
Period.
patio.
You can't even
That's
smoke on your
crazy.
patio.
Period.
Okay,
Our company's
period.
the same, but people still freaking smoke.
Yeah, so it's
You
up
have
to
guest overs, and what are you going to say? Oh, yeah, can't smoke.
go across the street. I have friends that smoke, I'll say you have to go across the street. Well, they can go up to the rooftop deck. Question.
As this relates to pre-construction, if there are like 100 condos under construction right now, their condo docs were already established.
Yeah.
Now they want to add this rule in there
Yeah.
after it's built.
Yeah.
Do all of the owners have to sign an amendment? or-
That, yeah, you know, that's a great, you know,
Okay.
that's a
that's
great
not-
point, but the condo corp hasn't even been formed
Yeah.
yet.
Closed it.
Yeah.
So, and
Yeah.
I kind of
4 years
suspect,
from now.
so that's a great question. I kind of suspect that somewhere in the agreements that the builder has a right to amend the declaration or the bylaws and rules and regulations. And whether or not your clients would have recourse to, I guess, maybe back out, I think they'll have to contact the builder.
Why would the builder care? They're just building the building.
Yeah, so, and truth be told, with most of these pre-construction agreements, because we act on quite a few of them, your clients have made so much money that I think that they'll accept that risk of not having to smoke and then just try to actualize their profits, right? So, I mean, I don't think many will walk away from that pre-construction agreement based on a smoking bylaw, potentially. Joe?
If these condo corps can, pass these bylaws, like how come they can't implement the same type of thing for these investors that own apartment buildings?
Sorry, I missed that.
No, like condo corporations, they can pass
Oh,
bylaws.
the reason why they can do that is
Yeah.
is because of the Condominium Act. There's actually substantial law there, okay? And specifically under Section 58, where the condo corp has to promote the health and well-being of the owners of the and residents of the
Yeah, but
condo.
wouldn't the owner or investors of an apartment building have the same?
They're tenants.
No, I know they have tenants, but aren't they responsible to have,
I think that-
a safe?
That's the landlords and tenants.
And how-
Yeah, I think you may have to go to the Residential Tenancies
Yeah.
Act and to be amended, but you're talking about politics now, so.
About pharmaceutical marijuana, about pharmaceutical.
Yeah.
What happens? Passing the new bylaws, and then
Right.
someone gets
So this is interesting.
a prescription
This is-
from
this
the
is-
doctor.
this is a
says,
great
"What
question
is my
here."
health? What to
So
do?
what if you have a license to smoke, and we've banned it, obviously, because the ban was on tobacco and 100% cannabis also, and even vaping, everything, okay? That was my question. If there is a challenge, I think it may have to go, they'll have to raise it with the condo board, we'll have to discuss it and whether or not we'll permit it or not. And then if it may be a
Human
part-
rights now.
You're talking about human rights.
Yeah, but can't they just have it in the pill
But this has
format or
happened in
edible
San
format?
Francisco, because I know.
Yeah.
They get a $100 prescription from the doctor,
Yeah.
and that's all.
Hold on, Monica?
Monica?
Going to the condo corp rules, bylaws, and declarations, can the corporation, can they just make up rules without the votes of the, I know you need 80% or 75% of owners' votes to make a bylaw on it.
Right, so we did it as a, when we did it, we passed it. Again, what we did is we forwarded it all to the unit owners,
Yeah.
and they had about 3 weeks or actually a whole month. And like I said, the pushback was out of the percentage very, very low. I thought it would be a lot higher. So they've got time to object, and then if X number of unit owners object, then we can hold a meeting.
Say it's not a condo, if someone owns a duplex or triplex or
Got it.
2 units,
Okay.
basement unit, whatever, and it's tenanted, just a house, it's
Okay.
not a condo. And as a landlord, can you ask someone, you can say this is a non-smoking, no pot, no whatever, smoking home, dwelling. If someone, can you ask them if they smoke for medicinal reasons? That if someone has to disclose, if a potential tenant has to disclose that they smoke or,
I think that would go to your standard form clause, no
It-
smoking is smoking.
but
That's when it would come
But
out.
what about
That's
if
where
it's
it comes out.
medicinal, it becomes a
I
human
have to
rights
tell you.
issue?
Can
Can you ask them, or does that become discrimination? Like,
Well,
if you say,
yeah, that's a touchy, that's a
Human
See,
touchy.
rights.
they could say, I smoke for medicinal reasons, you didn't give me the lease for that reason, and I feel discriminated.
Right, so
So then what happens?
I think what your tactic would be is to point to standard clause 10, no smoking. Have them sign off on it, because
Even if it's for
presumably,
health, even if it's for medicinal.
you're not gonna
reasons.
ask that. Presumably that
They would tell
information
them.
Okay, so then they'll
would be
say, well, then this unit
volunteer.
isn't for me, then
Then
they'll
you go,
say.
fine,
Yeah,
sorry to hear that.
Or if you have a tenant already in the building, in your house, your triplex or duplex.
Larry's on call now.
So say,
Thank you, Larry, for your,
so say they have, say somebody does smoke for medicinal reasons and the landlord has accepted that for whatever reason.
okay,
Do you have to disclose that to a person moving into the upstairs unit?
it's a good question.
Because then they'll say, this place smells like pot all the time and I didn't know
Yeah,
that.
and sort of, thank you for your input, Larry.
You
Well-
know, a disclosure and, you know, all of this.
You're gonna have a human rights issue, you're gonna have an LTB issue, because now they're, under the section 64, they're interfering with the reasonable enjoyment of another
Right.
tenant. It's
So
going to
you
be
have to
up.
disclose it, so you should disclose.
I'm not sure, if you do,
If I moved in somewhere and someone downstairs, it's a duplex.
I'm just, you're asking me landlord and tenant questions?
Oh, yeah.
Really? And to be honest, I'm not a landlord and tenant lawyer, so, but we're just here to put out the basics. I would err on the side of caution and say,
Yeah.
you're gonna have to call the LTB and get their
Yeah.
input and direction on
Because
that.
that's a potential.
That's a very serious issue.
Those are
Anytime,
issues.
we have to recognize the rights of persons.
Yeah.
It
Absolutely.
just sounds like
So
there's gonna be a
disclosure.
whole lot of can of
And
worms
also,
opened up.
health disclosure, if this is a medical prescription,
Yeah.
doesn't that go on a Privacy Act and everything?
Yeah, I think you may be impinging on their, you may have a case against yourselves if you're potentially discriminating, so you have to tread very carefully. What I would suggest is, I often refer our landlord clients to, there's this fantastic not-for-profit organization, I know I sent you a few of the emails, it's called landlordselfhelp.com.
They're fantastic.
Yeah, we're on, yeah.
Huh?
No, they're fantastic.
Oh, have you contacted Joe? Okay, so it's a not-for-profit organization. You can contact them as a landlord or your clients. I think you pay a small fee if you join them, or they'll provide free information to you. Okay.
Landlordhelp.com.
Landlordselfhelp.com. Okay. Now, just
So just a question, like, let's say somebody just, like, this is just for their house, like, their own personal use, they're growing, again, I don't know if these plants work, but they're growing 4 plants, like, everything's okay, like, kosher, they're growing them, like, year round. So when they go to sell the house, you have to disclose that they've grown marijuana in the home?
So we're going to come to that, because we've got a couple of sample clauses that we're going to see a lot of, and how we're going to try to tailor them to address this issue there. Just finishing out with condos, tenants have to agree to be bound by the rules, bylaws, and the condo declaration. Very, very important. So if you're working on leases and you present them the standard form lease and it's a condo, make sure you provide them a copy of the rules and bylaws also, so that they're aware of any non-smoking or no smoking rules or cannabis rules. That's very key to you, because they may argue that, hey, you didn't provide me the rules.
Where do you get that from?
So,
Well, from the condo board.
From the condo.
Or the property manager.
Gary, are we back to the same situation we had with the pets? Where it's written in every agreement and everybody moves in with the pets and then nobody can do anything about it?
This is different. Yeah, a condo board, you have to abide by the rules and regulations, period.
It says that though on the on the Wong form note.
Yeah.
Filled out.
So, again, maybe, but it's a different animal here, because we're talking about health and safety. Okay? Secondhand smoke. Clauses. Joe. So, we drafted a couple clauses, but you can alter them to suit your needs. It depends on which side of the fence you're sitting on, or whether you represent the seller or the buyer. So, 2 different clauses here, potentially. The seller represents and warrants that during the time it has owned the property, it has not contravened the Cannabis Act, and the property has not been used for the growth or manufacture of any illegal substances. It's
Anybody else for Gary? Because Gary, you have to do another set.
Oh, yes, I'm after your next
One
officer.
more question. When you said there was a case law that determined that if you smoke, even though you signed on the lease that you're not going to smoke, the Condo Act said that, yes, you are at fault. But that was the court. What would happen if you did it at a house when it didn't involve a condo? Would that still prevail?
That goes directly to the landlord.
So is there a case law on that side?
I'd have to take a look at that. The specific case that I saw involved the condo corp, the tenant, and the LTD.
2 different
Yeah, but
animals.
did the LTV declare that the tenant was in the wrong in that case?
It didn't get to the LTD.
Oh, it
It went directly to the courts. And so part of the arguments were, why didn't you let the LTP run its course and make the decision? They acted quickly, but the judge sided with the condo corp and the landlord. I thank you for your time, everyone.
Thank you, Gary.
If you have any questions, reach out to me.
Thank you.
And then we'll probably have to circle back in about 1 year. The cases will hit the courts. Thank you, everyone.